Let us talk about the Dr. Jayashree Lakshman Rao Patil versus the Chief Ministers and others case today, also famously known as the Maratha Judgement. Recently, the never-ending debate on reservation resurfaced in the country when the Honorable Supreme Court of India struck down reservations for the Maratha community in Maharashtra. In this video today, we will have a detailed discussion about the background, issues which were formulated by the Apex Court, and what was the decision of the court regarding the reservation given to the Maratha community. After the end of this video, you guys will be able to know the legal aspects of reservation vis-a-vis the Maratha Reservation judgment. So what happened was Maharashtra government constituted a commission known as the M.G. Gaikwad Commission to submit its report on the Maratha community's backwardness in the state. Based on the report of the Gaikwad Commission, the Maharashtra State Backward Class Commission gave its sanction to the Maharashtra government, and accordingly, in the year 2018, the government of Maharashtra gave the Maratha community reservation under the Maharashtra State Reservation of seats for admission in educational institutions in the state and for appointments in the public services and posts under the State for Socially and Educationally Backward Classes Act 2018, commonly known as the SEBC Act. The Act provided for 16% reservation for the Maratha community in educational institutions and appointments in the state of Maharashtra. So, the reservation to de diya. Problem kya hai? Now let us come to the problem part. Now the Act was challenged before the Bombay High Court, stating that it is unconstitutional. What were the grounds? Let's talk about them now. The major ground was that it breaches the 50% ceiling provided by the Supreme Court in the case of Indira Sawhney versus Union of India. And the other ground was that it violated Article 14, Article 16 and 19 of Constitution, creating a separate class outside the other backward classes to provide reservation for the Maratha community. What Bombay High Court in this judgment said, the High Court upheld the validity of the Act but observed that it should not exceed the limit of 12% and 13% reservation as recommended by the Gaikwad Commission. So basically, in a nutshell, what the High Court said was कि constitutional तो है Act, बस reservation जो 16% था उसको कम कर देना है, 12% educational institutions में और 13% government appointments में. So what effect the Bombay High Court judgment had? That's the big question. This had increased the overall reservation ceiling to now 64% and 65% respectively. In 2020, numerous cases were filed in the Supreme Court against the order of the Bombay High Court. And on the 5th of May 2021, a 5-judges constitutional bench of the Supreme Court gave its judgment. What were the major issues dealt by the Supreme Court? Let's come to that. The main question before the Supreme Court was whether judgment in the case of Indira Sawhney versus Union of India needs to be revisited in the light of the subsequent constitutional amendments, judgments, and changed social dynamics of the society. The court answered the question in negative and held that to change the 50% limit is to have a society which is not founded on equality but based on caste rule. Thus, answer to the question posed is that the percentage of 50% reservation has been arrived at on the principle of reasonability and achieves equality as enshrined by Article 14, of which Article 15 and 16 are also facets. So basically the court said कि Article 14, 15 और 16 के हिसाब से नॉर्मल सिचुएशन में 50% रिजर्वेशन है, रीजनेबल है और उससे ज़्यादा की ज़रूरत नहीं है. The next major question was whether the reservation for Maratha community in addition to 50% social reservation was covered by exceptional circumstances as contemplated by the constitutional bench in the Indira Sawhney case. Supreme Court ने क्या बोला? Marathas are dominant forward class and we are in the mainstream of the national life. Further, the Gaikwad Commission had failed to justify extraordinary circumstances, as it had made a mistaken assumption that the limit could be breached if there was a quantifiable data. Just because a state had a huge or a large population of backward classes, the limit could not be breached. That could not be the only reason behind the judgment. The court went on to hold that a separate reservation for the Maratha community violates both Article 14 and 21 of the Constitution of India. One of the most controversial part of the judgment was the decision on the question whether the 102nd Amendment of the Constitution deprives the state legislature of its power to identify the backwardness in its jurisdiction, was answered negatively again by a majority of 3-2. This therefore in extension upholds the insertion of Article 342A by the 102nd Constitutional Amendment, which locates exclusive competence to decide backwardness with the central government. The court categorically stated that the President, that is the central government, alone to the exclusion of all other authorities is empowered to identify SEBCs and include them in a list to be published under Article 342A, subclause 1, which shall be deemed to include SEBCs in relation to each state and union territory for the purpose of the Constitution. The last question before the Apex Court was whether Article 342A of the Constitution affects the federal policy or the basic structure of the Constitution of India. The court held that Article 342A did not violate the principle of federalism, that the threshold to prove a basic structure violation in the case the principle of federalism is very high, only if the law completely takes away the very essence of federalism or effectively divests the federal content of the Constitution and deduces the state of their effective power to legislate or frame executive policies, could it then be considered as a basic structure violation and otherwise not. The shifting of identification of SEBCs from the state government to the centre does not pass this threshold clearly. So, what is the present situation now? The central government has filed a review petition in the Supreme Court of India against its decisions with respect to the Maratha Reservation. The petition challenges the majority view of its 5 judges under Constitution bench that only the centre or President of India possess the power under the 102nd Amendment to identify and list socially and educationally backward classes and not states. The said petition is pending before the Apex Court. So, what all have we learned from this judgment? Judgment of the Apex Court in Dr. Jessup Lakshman Rao Patil versus the Chief Ministers and others. Number 1. No need to visit Indira Sawhney judgment, that is, reservation cannot exceed 50% unless there exists some exceptional circumstances. Secondly, what do we learn? The Maratha community are dominant, forward class in the state and no exceptional circumstance is there to provide reservation to them. Thirdly, the President, that is the central government, alone to the exclusion of all other authorities is empowered to identify SEBCs and include them in a list to be published under Article 342 capital A. Next, what do we learn? Article 342 capital A, which was inserted by the 102nd Constitutional Amendment Act, does not violate the basic structure of the Constitution. I hope this video helped you in understanding the concept of reservation. If you have any opinion, you can write it down in the comment section right below. Thank you so much.